So with that said, I want to now turn it over, as I said, to our host today. She is the Director of Management Services over at Artemis Lifestyles. I'd like to introduce Diane Skinner. Diane, the floor is yours, my friend.
Thanks so much. Thank you everyone for joining us today. I am Diane Skinner, as he said. I'm the director for the Tampa market. So Artemis Lifestyles is growing. We're pretty excited about that. We have our corporate offices in Kissimmee, but we service the whole Orlando area. We also have an office in Brevard. We also have presence up in Lake County. And now we are growing in the Tampa market. And yesterday I was at one of our properties in Venice as well. So we're servicing the west coast of Florida as well. So that's kind of what we wanted to announce. We're a full service management company. We service HOAs, condominiums. We also have a lifestyle division. So we have a lot of fun in our lifestyle with our lifestyle component. So that's kind of what I wanted to share with you today. And we want to thank our gracious attorney for coming on board with us and teaching this class today. I'm sure it's going to be good for you and give you a lot of good information moving forward. So thank you and welcome everyone for joining us today.
Thank you, Diane. And now we'll turn it over to our presenter today from Kaye Rembaum. She's the managing attorney over in the Tampa office over in Hillsborough County, Kerstin Henze. Kerstin.
Well, hello. I was about to say good morning, but it's lunchtime. So my name is Kerstin Henze, and like Jeff mentioned, I am a partner and the managing attorney of the West Coast office for the firm, Kaye Rembaum. For those of you that are not familiar with the firm, our main office is located in South Florida, in Pompano Beach, Florida, but we also have other locations in Palm Beach Gardens, Orlando, and like I mentioned, the West Coast office, which is located in Tampa. We do, however, service pretty much any condominium, homeowners, or co-ops really throughout the state of Florida. But if you are located in the West Coast, then I would be the closest contact to you. All right, well, with that said, let me go ahead and share my screen and start on today's presentation. Give me a minute here. All right.
Looks good. We can see it.
Can you see it? All right. Oh, let me scroll all the way to the beginning. All right, very good. So today we're going to talk about updating your governing documents. I'll go through the slides, and then what we'll do is we'll take questions towards the end. So if you have questions about anything that I mention throughout the class, go ahead and type it in the chat box, and we'll try to address it at the end. Okay, let's start with hierarchy of the governing documents. So whether you're in a condominium association or homeowners association governed under 720 or 718, you have a certain number of documents, okay, of which 3 would consist as your governing documents. And they are your declaration of condominium, if you're in a condominium, your declaration of covenants and restrictions, if you're a homeowner association, and then you'll have your articles of incorporation and your bylaws. Now, in terms of hierarchy, the declaration of condominium or the declaration of covenants is going to be your supreme document. It is really the constitution, the contract between the owners that buy into your community and the association. It's the document that's going to contain your use restrictions, what you can and cannot do, your assessment authority, and other provisions. Your articles of incorporation and your bylaws would be next. The articles of incorporation, it's the document that basically sets out your corporate structure. Who constitutes a member, who qualifies to run and serve for the board of directors, for officers, etc. That's the document that needs to be filed with the division of corporation when the association is first created. And every time you amend your articles of incorporation, the amendment needs to be filed with the Division of Corporation in Tallahassee. Now, your bylaws are really going to be an extension of your articles of incorporation. So it's going to contain basically a little bit more detail than what your articles provide. If there's ever a conflict between the articles of incorporation and the bylaws, the provisions in the articles will control. So it's important when you amend your bylaws not to forget to take a look at your articles of incorporation to see if there's any provision that addresses the same clause or the same issue that you're trying to amend in the bylaws. And if so, amend that out as well. Otherwise, you're going to have a conflict between the documents. And then you might also have rules and regulations or, architectural specifications or standards. Those are not part of your governing documents, okay? Those are separate and distinct. More likely than not, they would only require the approval of the board. But always check your governing documents, as I have seen over the years, governing documents that require membership approval to amend rules and standards. All right, let's go on to the next slide. All right, the amendment process. So I'm briefly going to talk about the amendment process, and then we'll move on to certain types of amendments that I'm going to highlight that you might want to consider undertaking. All right, so to amend, the first thing really starts with typing up the language in the document that you want to amend, okay, and then designating the changes with underlines and strike-throughs, okay? The condominium and the HOA statute both require that any changes to your governing documents are designated with underlines and strike-throughs, okay? So any new language that you add will be underlined. Any language that you are deleting will have a strike-through. Now, there is an alternative to that both statutes allow. And that is, if you're going to undertake significant changes, for example, if you are completely redrafting your use restriction provision, of several pages, and the underlines and strike-throughs might be too distracting or might hinder the ability of owners to understand or, process the changes, then the statutes allow you to amend the language without designating underlines and strike-throughs. Instead, you would have to put language at the top of the amendment to the effect of, this is a substantial rewarding, see the original language of the original document. Okay, so that is an option. Now, whether that is the best option for your community, that's something for you to discuss, among yourselves as board members and possibly even with legal counsel. Now, once you've drafted your amendment, the next thing is presenting the amendments to the membership for approval. Okay. Most amendments will require membership approval, and you'll have to go to the specific governing document that you're amending to confirm what that approval requirement is. Okay. Now, if the amendment requires membership approval, you have two options. You can present the amendment to the owners for approval at a membership meeting, okay? Or in the alternative, you can present the amendment through the written consent process. Now, if you're presenting the amendment at a meeting, this could be either at an annual meeting or at a special membership meeting. Most communities, typically with HOAs, don't have as many membership meetings. And remember, membership meetings are meetings at which owners vote, okay? Board meetings are meetings at which the board takes action, okay? So typically, your community might not necessarily have a lot of membership meetings, and some boards prefer to present amendments at their annual meeting, which is typically the one and only meeting the association will have, and it's the one meeting where most owners come. Okay, so if you're doing the amendment process at a meeting, then you will likely mail out a notice of your meeting along with a copy of the proposed amendment that you're trying to get approved. as well as a proxy, okay, which is the second bullet point. So the limited proxy is typically what you would mail out with an amendment. Now, proxies are good for 90 days, and this is whether you're in condominium or an HOA, they're good for 90 days from the date of your first meeting, okay? Now, the reason this is important is because let's say your first meeting is, June 1st, and you've mailed out the notice in advance, you've mailed out the limited proxies, and on June 1st, you don't have enough proxy votes or ballots from those who are present to pass the amendment. Well, since the proxy is good for 90 days, that means that you can recess and reconvene your membership meeting as many times as necessary up to that 90th deadline in order to get the votes that you need. Okay, there is a process to properly recess and reconvene the meeting, so get with legal counsel on how to do that, because once you adjourn the meeting, that means the meeting is over and you would have to restart the process again. Okay. Now, with the written consent process, first of all, it's only an alternative if you have the authority to do that. With condominiums specifically, you have to have specific authority in your bylaws authorizing you to present issues to the owners through the written consent process. If you do, the written consent process, essentially, it acts like a proxy vote. Instead of mailing out a notice and a proxy, you would mail out a memorandum with a consent form. The memorandum would essentially outline what action you're asking the owners to take, in this case, to consider a proposed amendment. And then only if the owner consents to this amendment, they have to sign at the bottom of the consent form and then return the consent form to the association. So essentially, if an owner is not in favor of the amendment or just has no interest in casting a vote, then they don't have to return the consent form. Now, with the written consent process, the association will have 90 days from the date of the first executed consent form to get the necessary votes. So once you mail out your consent form, and let's say your first executed consent form is returned, June 1st, and you'll put in the memorandum, please, if you're in favor of the amendment, return it by June 1st. Let's say you get your first consent form June 1st. Well, you have now 90 days from June 1st to get the requisite consent forms that you need to get the amendment passed. All right. So distribution to the members, that has to do with how you can distribute the proposal to the owners. And really, you can either mail it, you'll confirm it with your governing documents, but typically you can mail it to the owners at their address that appears in the official records of the association. You can hand deliver it, or you can email a copy of the amendment, the notice, or the written consent, whichever way you decide to present the amendments to the owners for a vote. But with the email option, you're only going to email it to those owners who have consented in writing to receiving official notices from the association. Okay, so if you do not have a written consent from an owner consenting to receiving email notifications, then that cannot serve as your official notice to the owners of the amendment proposal. Then you'll have to either mail it or hand deliver it to the owner. All right, vote tally. So vote tally has to do with what is the percentage of owner vote that you'll need to get the amendment approved. So again, depending on what document you're trying to amend, for example, if you're trying to amend the declaration, then go to the declaration. There should be a provision in the declaration that tells you what is the owner vote that you need to get to amend the declaration. If you're trying to amend the bylaws, then you'll do the same under the bylaws, okay? So if your documents are silent, then with HOAs and condominiums, you'll need to get a vote of 2/3 of the voting interest to amend. Okay. Now, if you happen to have a very high voting threshold to get the amendment approved, and typically that would be 75% of the membership or 2/3 of the membership for some communities, then you might want to consider, before presenting any substantive amendment to the owners for approval, consider presenting an amendment that reduces that voting percentage. So an amendment that reduces the voting percentage, let's say from 75% to maybe a majority of the owners, okay? Once you present the amendment to the owners and the amendment gets approved and recorded in the public records, then at that point, consider presenting the more substantive changes to the owners, okay? Because at that point, the vote you'll need to get on those substantive amendments would be the lower vote, okay? All right, material amendments. So those amendments refer to amendments that try to change or reduce the voting percentage of owners, percentage of common elements that owners might own, or the percentage of assessments that owners have to pay to the association. Those type of amendments are considered material and typically will require a vote of 100% of the owners and their mortgagees, which is why it's very difficult to change the percentage of assessments that owners pay. Okay. Now, leasing and rental amendments. I just want to briefly point out that with leasing amendments, for example, if you're considering an amendment to modify the term of a lease, for example, owners cannot lease more than one time in a 12-month period, and the lease cannot be less than 12 months. If you're considering those type of amendments, or if you're considering prohibiting an owner from leasing, or you want to impose some kind of rental cap or lease moratorium, well, Chapter 718 of the Florida statute says that those types of amendments are only effective against owners who vote in favor of those amendments, and then owners that take title to a unit after the amendment becomes effective. Okay. Now, if you have Kaufman language, and I'll talk about Kaufman in a moment, but Kaufman pertains to the magic words as amended from time to time after reference to Chapter 718 in your declaration. So if you have that language that your declaration is subject to 718 as amended from time to time, then substantive changes to the statute will apply to your association condominium. So in that case, this section of the statute pertaining to lease would apply. Now, if you don't have Kaufman language, you could make a constitutional argument that portion of the statute doesn't apply. I'll leave it at that at this point. Something for you to discuss with your legal counsel, but just want you to be aware that there is this additional restriction on lease amendments. And then for homeowners associations governed under Chapter 720, there was a change in the statute in 2021, I believe, that incorporated a similar restriction for lease amendments. Okay. So again, if you're considering amending your documents as to leasing, just speak to your legal counsel as to how the statute would apply to your community. Now, suspension of voting rights, that might be a useful tool for your association if you're trying to get an amendment passed. And essentially, if with, let's say, homeowners associations, if you have owners who are delinquent for more than 90 days and any monetary obligation owed to the association, then the association has the ability to suspend voting rights. And I'm not going to talk about the process of suspending voting rights, but just know that if voting rights are properly suspended, then the effect that it has is that it will reduce the voting percentage, okay, that you will need to get these amendments passed. So let's say you have a community of 100 homes and 10 owners have been delinquent on their monetary obligations owed to the association for more than 90 days, and the board has properly suspended their voting rights. Well, now you need, instead of getting, let's say your documents require a vote of a majority of the owners to get the amendment passed, well, instead of getting having to get a vote of the majority of the 100 owners, now you would need to get a vote of only majority of the 90 owners. Okay, so that's how that would work. And then for condominiums, there's also authority in the statute for associations to suspend voting rights for those owners who are also more than 90 days delinquent on their monetary obligations to the association. And the monetary obligation has to be at least $1,000 delinquent, okay? And last bullet point here is mortgagee approval. Check with the governing documents that you're trying to amend. It's quite possible that in the amendment section, there's a requirement to obtain mortgagee approval, the consent of mortgagees, if the amendment affects their priority of lien or it affects their interests. Okay, so for example, an amendment that prohibits leasing could be potentially argued as affecting mortgagees' rights once a mortgagee takes title to a unit, right? Because they become an owner just like anyone else and could potentially lease the unit. So if you are now removing the ability of owners to lease, well, it could have an effect on mortgagees, and that might be an amendment that you might require mortgagee consent. Now, the statute for 718 and 720, they do provide a statutory process by which to get mortgagee consent. Okay, so get with your legal counsel if you want to go through the process of getting mortgagee approval. Otherwise, the amendment could be potentially successfully challenged by a mortgagee when it comes time to enforcement. Okay. Now, the mortgagee will have 5 years from the date the amendment is recorded to legally challenge the amendment. Okay, so speak with your legal counsel as to whether this, whatever amendment you're considering is one that you are willing to take the risk on a mortgagee challenge, or whether you should go through the mortgagee approval process. All right, so let's shift gears. All right. True or false? We're going to talk about a number of misconceptions and possible areas where you might want to consider amending. So what provisions are illegal? I mean, essentially, you want to make sure that your amendments do not violate, fair housing laws, that they don't discriminate against buyers and tenants, families with children. So as long as the amendment is not discriminatory or violative of the law, such as fair housing laws, then the amendment should be enforceable. Okay. Now, what provisions are holding you back or costing you money? Let's take our first example. All right, so a foreclosing lender is required to pay 1% of the original mortgage debt or 12 months of delinquent assessments. That statement true or false? Well, it's true in the sense that this is what is referred to as the safe harbor. Okay, both 718 and 720 have language that says if you're a first mortgagee, right, that takes title to a unit, well, then you're responsible to pay either 1% of the original mortgage debt or 12 months of delinquent assessments. The problem is that this amount is not guaranteed, and it depends on what your governing documents provide. So look at your declaration, because it may contain language that provides mortgagees with greater protection. It might actually have language that says that a mortgagee that takes title to a unit or a lot is not liable for any assessments that came due prior to the mortgagee taking title. Okay, unfortunately, mortgage lenders have been successful in using that type of language in the governing documents to defeat, or to get away with not paying anything. So the bottom line is check what your governing documents have. And if they have this language, then you might want to consider amending it, okay, to require mortgagees to pay the safe harbor amount. Okay. Now, again, this type of amendment might be one that might require mortgagee consent, depending on what your documents provide. If so, then you want to get with legal counsel to discuss the options of getting mortgagee approval or potentially taking a risk on a legal challenge. That is a business decision after you speak with legal counsel. All right, the next misconception. All new owners must go through the screening process in our community. Well, that is false. And it's false because, number one, the statute, neither 718 nor 720, address the screening process of purchasers or tenants or any other applicant. Okay, that is going to be document specific to your documents for your community. So check your governing documents. Do you currently have existing language that authorizes the board to approve or disapprove purchasers? Okay, if so, great. If not, then you might need to amend your governing documents to give you that authority. This specific authority needs to be in your declaration for best enforcement, not as a rule, not as a policy, not in your bylaws, in your declaration. Okay. If you do have authority to screen new purchasers, well, do you want to have the authority to screen other types of applicants? Okay, what about quitclaim deeds or gift conveyances, right? They're not your traditional sale. If a parent wants to add, an adult child to the deed, right? Or if an owner wants to add, someone else to the deed after that owner got approved, do you want to be able to screen these individuals? Okay. If so, and you don't have authority, then that might be an area of amendment for you. Look at your documents. There might be language that says, if the mortgagee takes title to a unit, well, you can't screen the mortgage company when that mortgage company later wants to lease the unit or later wants to sell the unit. Sometimes that transaction is exempt from board approval. You might want to consider amending to require board approval for those types of transactions. Now, you could have in your documents exemptions for other types of parties, for example, spouses or children or parents. Are these individuals the type that you also want to screen or not? What about additional occupants after the owners have been approved or after the tenants have been approved? Some associations refer to them as guest occupants. Do you want to screen them? Okay. You don't have an automatic right to screen these occupants unless you have specific authority in your governing documents, specifically the declaration. So speak to your legal counsel about possibly amending your documents in that regard. Now, if you are authorized to approve or disapprove buyers or tenants, or you want to have that ability, what about, do you want to also be able to charge an application fee or a transfer fee, as it's referred to in the Condominium Act? You need to have authority in your declaration to be able to charge that application fee. It's not automatic. Okay, so that might be another area of amendment. If you have the ability to authorize to approve or disapprove tenants, do you want to be able to also charge a security deposit? If so, that's an amendment that you would need to also consider. What about good cause criteria? You want to be able to have criteria upon which you can disapprove a buyer and a tenant. Those should be set forth in your governing documents for best enforcement. So you might want to consider amending your documents to add those good cause criteria. Okay, the next slide. Once the law changes, the change is automatically applicable to your community. Is that true or false? Well, it's false. This is what I mentioned earlier refers to the Kaufman language. And Kaufman language is what you'll typically see in maybe the opening page of your declaration that says that this community or this association is governed under either Chapter 720 or 718 as amended from time to time. Okay, it's that as amended from time to time language that's referred to as Kaufman. Now, there's two types of changes that can be made to a statute, either procedural or substantive. Now, substantive changes typically affect the vested rights of owners, such as in the case of leasing that I mentioned earlier. Procedural has to do more of, for example, election process, right? These are just procedural changes. Now, this is a very complicated area of the law, and I'm very much simplifying it here, but essentially, a change to a statute cannot impair existing contract rights, right? So remember I mentioned your declaration is a contract between the owners and the association. Well, if the legislature makes changes to the statute, it can't impair existing contractual rights. So if the change to the statute is procedural, under the law, they will apply to the association and the community regardless of whether you have Kaufman language or not. However, if changes to the statute are substantive that affect vested rights, then one could make a constitutional argument that that particular change to the statute cannot be retroactively applied to your community, right? Because it impairs a vested contractual right. So this becomes an analysis that you're going to have to make with your legal counsel as to whether certain changes apply or not. So the question you need to ask yourself is whether if you don't currently have Kaufman language, whether you want to add Kaufman language to your documents. And if you have Kaufman language, whether you want to take it out of your governing documents. Again, this is a bit of a complex analysis beyond the scope of this particular class, but do get with your legal counsel to discuss how best to address Kaufman language for your community. Okay. The board must obtain a vote of the owners before making any material alteration. Is that true or false? Well, false. For condominium associations, material alterations is a concept of condominiums. As you may be aware, the condominium statute does say that unless otherwise provided in the declaration, the association needs to obtain a vote of 75% of the owners in order to approve material alteration to the common elements. So that means that you have to go to your governing documents to see what voting procedure is in place for material alterations. If your governing documents are silent, then you defer to what the statute requires, which is the approval of 75% of the owners to make a material alteration change. But you might have something else. You might have a provision that requires a vote of the majority of the owners for material alterations. You might actually have a provision that provides a dollar threshold amount that might require a membership approval. So, for example, if you're considering a material alteration, the board can do alterations up to a certain dollar amount. But if the cost of the alteration exceeds that amount, then that's when you need to obtain membership approval. So again, look at your governing documents. And I've actually seen governing documents where membership approval was not required at all for certain types of material alterations, such as painting of the exterior of the condominium. Okay, so it's going to be specific to your community. There is an exception to this material alteration requirement, which is called the necessary maintenance exception. And I just want you to be aware of it. And that is an exception that says that if you are and it's developed in case law, so it's not going to be in the statute. But if the association is considering or has to undertake a maintenance obligation, right? You have to do concrete restoration, or you have to do a roof replacement, right? That's part of a maintenance obligation of the association. But in doing so, there's going to be some alteration, okay, depending on what it is, then that would be considered a maintenance issue, not so much a material alteration issue. Now, sometimes that line is gray, and you would need to speak or consult with your legal counsel as to whether the particular work that you're undertaking falls under this exception or not. Okay. For HOAs, material alteration is not a concept of HOAs. Okay, so there's nothing in the statute addressing material alterations under 720. However, what is more common with HOAs is that you might have a provision in your declaration or bylaws requiring membership approval if the association expends, certain dollar amount for certain types of capital improvements. Okay. So then again, you have to consider, is this really a capital improvement, or is this more of a necessary maintenance issue? Okay. All right, next slide. Delinquent assessments accrue interest at the rate of 18% and $25 late fee applies. Well, the statement is true in that is what 718 and 720 provide, but it might not be true for your community because it'll depend on what your governing documents provide. So first, with regard to late fees, you need to have specific authority in either your declaration or in your bylaws in order for the association to be able to charge a late fee on delinquent assessments. Now, if you do have the authority, the maximum that you can charge a delinquent owner, it's either $25 or 5% of each delinquent assessment. But again, the authority to even charge that has to be in your governing documents. Now, if we are amending your documents and I'm adding authority to give you the ability to charge a late fee, I wouldn't necessarily include the actual dollar amount, right? Because the statute could change. So rather than identifying the dollar amount in the amendment, I might draft the amendment to say, the board has the authority to charge a late fee on delinquent assessment up to the maximum amount allowed under the law, as amended from time to time. This way, should the statute later change, well, that change would be incorporated into this particular amendment, and you wouldn't have to amend the rates every time. Okay. Now, with interest, with condominiums, interest can be charged at the rate that's provided in the declaration. So with some of the older declarations, I've seen where the association can charge a maximum of, let's say, 10% or 15%. So even though the statute says 18%, if your declaration of condominium specifies a different amount, okay, that's less than 18%, then that's the amount that you're stuck with. Okay, now if your documents don't identify a specific rate, then you're defaulted to 18%. So again, it becomes important to see what your governing documents provide and then possibly having to amend to give you the maximum authority to charge interest and late assessments. And I'm sorry, late fees on delinquent assessments. Okay. All right, next slide. So if a pipe in a wall only provides service to one unit, that unit owner is responsible for maintenance. Is that true or false? Well, that depends. Maintenance issues are not specifically addressed in the statute. And specifically with condominium associations, the statute only addresses insurance. obligations, not maintenance. So for maintenance, for both HOAs and condominiums, you have to go specifically to your governing documents, your declaration. So the declaration of condominium will identify the boundaries of the unit and what owners are responsible. So just because a specific pipe services a particular unit owner, that doesn't necessarily mean that that's the maintenance obligation of the owner, right? So, check your governing documents. Very often, in my experience, boards think that the association has certain obligations or that the owners have certain maintenance obligations, when in fact it's quite the opposite. So check how you currently operate against what your declaration provides. And if it's different, or if you want to shift maintenance responsibilities to the other party, then that will require an amendment to your declaration. Now, specifically with maintenance, you also want to make sure, check your declaration to see if you have incidental damage language. So incidental damage language would basically say, if the association, let's say the association has to repair a pipe that's behind a drywall. In order to get to that pipe, the association is going to have to break through the backsplash of kitchen counter. Okay. If you have incidental damage language, okay, it would say that the association is basically responsible for damage to the backsplash, okay, that it causes in order to get to the pipe behind the drywall. Okay, so you might want to consider amending your declaration to remove that incidental damage, because it could subject the association to additional expense every time it needs to undertake a maintenance obligation. Also, you want to check your documents to see if you have what is referred to as self-help remedy. So self-help remedy is basically would give the association authority to undertake the maintenance obligations of the owner if the owner fails to undertake his or her own maintenance responsibilities. So it would allow the association to enter the unit, do what you need to do in order to, repair or maintain what is the owner's responsibility, and then more often than not, also authorizes the association to charge the owner for that expense. Okay. Well, there's been case law recently in Florida that essentially states that if you have self-help remedy in your governing documents, the association is now forced to undertake that self-help remedy, or at least try, before the association can file legal action in court to force the owner to undertake that maintenance responsibility. And that applies even if the self-help remedy is more of an option rather than an obligation. So you have to first basically, attempt to do the maintenance responsibility of the owner before you pursue legal action against the owner to force the owner to do it. Self-help remedy is just not the recommended approach in every instance. Should be considered on a case-by-case basis, because it could subject the association, unfortunately, to unnecessary liability when you enter into a unit to undertake the owner's maintenance responsibilities. So it's not always recommended. So discuss that with your legal counsel if that's something you want to amend out of your declaration, if you do in fact have self-help remedy. Okay, so I think we've come to the end of the slides. So what have you learned today? Essentially, we've talked about safe harbor mortgagee liability, which may be limited by old language in your documents. We talked about the association possibly losing money from interest and late fees. And again, these are only a few concepts, a few points that I'm bringing up for purposes of this class. Obviously, you might have other issues, concerns, and areas that you might want to amend to, streamline the operations of your association, or to better protect the interests of the association and the owner. So, again, that's something that you might want to discuss with your legal counsel. All right, and then a fun slide at the end, healthcare alert: owning a home in an HOA may be hazardous to your health. Let's see, there's a question. How can membership veto a rule change by the board at the actual meeting where the rule change is happening? Well, the membership can't typically just veto a rule change. There has to be some language in your bylaws requiring the board to present a rule change to the owners within a certain time frame, and then giving the owners the authority to overrule that. Absent that, the membership can't just overrule a rule. Now, there could be issues in enforcing the rule, and then the owner could have a basis to legally challenge the enforcement of the rule, but that's different.
And a couple of you, Kerstin, while you're looking at the Q&A, I have only one person in the Q&A that says the link is not active. If it's not working, copy and paste it, try it again, but I haven't seen anybody else saying it's not working. I just tested it on 2 different browsers and everything is functioning properly. Back to you.
Okay. Let's see. So the question is, so I have a community that does not have any provision for screening. Does the association need a majority vote to add this to the declaration? Especially since it's a safety issue to the background checks and credit checks. So 2 things. So if we're talking about the authority to approve or disapprove, purchasers or tenants or any other type of occupant, the authority to do that has to be in your declaration. Okay, not as a rule, not as a policy, not in your bylaws, in the declaration. Now, the vote that you might need to get that amendment passed will depend on what your declaration requires. So you'll need to look at your declaration for that. I mean, it could be a majority, could be something else. And yes, while the safety of residents is certainly an issue, that is an amendment that needs to be approved to the declaration to be enforceable. Let's see here. If your association does have a right to screen and does require board approval, can you deny someone based on their credit score or background if not specifically outlined in their documents? Depending on what the language of your documents, contain, yeah, you might be able to consider negative credit or negative criminal background as a basis to disapprove. But again, at the very minimum, you want to at least adopt a policy. If you have the authority to approve already, you want to adopt at least a policy that identifies the good cause criteria upon which you disapprove. That will eliminate a lot of the claims for discrimination, because now you have a uniform policy that hopefully you are applying across the board. Otherwise, you can see how it would be easy for an applicant or an owner to claim discrimination, or just challenge the disapproval. This is an interesting question. When is a rule overreaching and becoming a change to the governing documents, especially about screening roommates or owners? So in Florida, the enforceability of a rule has to pass a 3-pronged test, essentially. Okay, number 1, the board has to have the authority to adopt the rule that they're trying to adopt. So you have to look at your governing documents to see if you even have the authority to adopt the rule you're trying to adopt. The second prong is that the rule cannot conflict with the declaration. And this is why certain restrictions have to be put in the declaration as opposed to being adopted by a board may rule. So if your declaration is silent about an issue, for example, if your declaration is silent on pets, okay, and the board now goes ahead and adopts a rule prohibiting pets, well, under the law, the fact that the declaration is silent on pets, okay, there is a legal presumption that pets are not restricted or unrestricted, I'm sorry. So that means that you can have pets. So now if you adopt a rule that says you can't have pets, well, it's going to conflict, okay, with the declaration, which is why that particular restriction would then have to be in the declaration in order to be enforceable. So when you adopt rules that really should be in your declaration, you essentially subject the association to potential legal challenge. The owner who gets an attorney could legally challenge the rule on that basis. It should be an amendment requiring membership approval. Okay, so when you're considering restrictions for your community, best to speak with your legal counsel as to whether you can adopt it as a rule or should be in the declaration. Let's see here. How does an HOA notify mortgagees that a declaration change is being considered? There's a statutory process outlined in both 718 and 720 of how you need to notify mortgagees. Essentially, it acts as a negative notice process. You have to do a title search on the owners to confirm who has mortgagees. You have to then contact the owners to confirm if that is the mortgagee that they're currently paying their mortgage to. And then ultimately you have to send a letter to the mortgage company that was reflected on that title search. Okay, and you basically give them 60 days to respond back with any objections. And if you don't hear back from them, then it acts as a consent to the amendment, basically. It's a negative notice process. So I would speak with your legal counsel a little bit more about what that process entails. Let's see. So another question is, my association's governing documents were first written in 1985. After the original developer went bankrupt, the next developer revised the documents in 1996. No other versions or updates have occurred. What would the process be or recommended to begin updating to bring the documents to current century for a community of about 1,500 homes? Well, I mean, I can tell you, I've been doing overhauling governing documents for communities for a long time, to the point that, in my opinion, the way we do it, the way I do it, it's a two-step process. And obviously every attorney is different, but I do it in a two-step process. The first step really is to review the governing documents, start to finish, all three of them, and then prepare a comprehensive letter to the board with all the recommended changes and suggested changes. And then the second part is to actually undertake the redraft of the documents, with taking all the changes that I've recommended in the draft. So I think if you want to discuss more the document rewrite process, just send me an email, give me a call. I'm happy to go into more detail. But that's the general gist of how we've handled document rewrite projects. Let's see. I think maybe one more question.
Sure. And before you read the one more question, there was one here for me, a technical question.
Yeah.
It says there are two of us taking the webinar together, so she can't get the certificate, and that's understandable. You might be in a conference room, that kind of a thing. take the link that's in the chat and send it to your friend. And when your friend fills out the evaluation, if this is a case with some others, just jot down in field number 10 who you were watching with and that person's email address so we can verify that that person was actually here. So we've got you covered either way.
All right, just last question. Can you vote electronically to amend the documents? Hard to get a quorum. Absolutely. You know, amending documents, amendments, that's definitely an issue that can be presented to the owners, and they can vote electronically if the board properly adopts or allows electronic voting for your community. There is a statutory process for 718 and under 720 of how to do that. So get with legal counsel and how to adopt electronic voting for your community. But that would definitely be helpful.
Okay.
I
And
think that's it.
great job. I know, as I mentioned earlier, there's always a ton of questions that we don't get to in the time allotted. So we got to as many as we could that are closer to topic than others might be. So thank you for that, Kerstin. Diane, before I go over some more nerdy technical stuff, I'm going to hand it over to you. But before I do that, I had another question just now in there on the technicals thing. We have a couple of hundred of you trying to fill out the evaluation at the same time. And in the past, if you tried buying Taylor Swift tickets as soon as they went on sale at Ticketmaster, when you have a lot of people doing the same thing at the same time, the website can time out. So hang on to the link if it's not working for you now. I see it's working for most of you. I can see them coming in on the back end. But if it's not working for you, hang on to the link, maybe text it to yourself, email it to yourself, do it again a little bit later. It should work without an issue. But again, we have many of you trying to do it at the same time. So before I go over the evaluation process one more time, I want to turn it back over to our wonderful host today at Artemis Lifestyles. Y'all do a great job. Diane, do you have anything you'd like to say before we head out today?
No, I'd like to thank Kerstin. It was really good, really informative. I know we had a lot of questions in the chat. There's some questions that we didn't get to. So if you still have some questions, reach out to us. We'll try to get back to you on that. If you, you know, are out there needing any management services, of course, reach out to us. You need any, you know, legal counsel advice, reach out to them. And, you know, we're just here to, you know, to try to help everybody, try to assist and try to help you with your education as much as we can as well. So I hope you learned something. Thank you so much. Thanks for joining us.
Thanks for having us. And Diane, I know you have a busy day, just as Kerstin, appointments, whatever it might be. You're welcome to head out, hang on, whatever you want to do, because after Kerstin gives her parting words, I'm going to go over the evaluation process one last time. And folks, if you have any technical questions, okay, I know a lot, but I'm not an attorney. I can't answer those kinds of questions. You can place your technical questions into the chat. I've just opened it up so you can communicate with me about something that may not be working. While you're doing that, Kerstin, your parting words?
Yes, thank you so much, Diane. Thank you, Jeff, and thank you everyone for spending your lunch hour with us. I hope you took some information, valuable information from this class. I am available. You can reach me, you know, by email or by phone. We're here to help. So thank you so much.